We have with us on the IJAP panel, the Honorable Justice Professor Moji Owaye, the chairman of the panel. We have sitting next to him, Dr. Andrew Mamedu, who is the company director, Action Aid. And to his right, we have Professor Jume A.N. LG. And to Mamedu's left, we have Justice Dr. Adepope Okoye, a retired Justice of the Court of Appeal. And to my right here, we have Professor Okechukwu Ibianu, here right beside me, and next to him is Barrister Sejap Sokwa, member of the panel. And on the other side, next to Justice Adepope Okoye is Barrister Mrs. Rumi Secretarian, member of the panel. And then next to her is
I know you saw the wrong. I didn't know the wrong number. Okay. Good morning. I'm Azam Isaboko, cameraman from Haiti.
Thank you very much. Thank you very much. So we'll now proceed with the press conference, and of course, we follow with an interaction, Q&A, and I need to ask questions on any areas of my interest. And now I'm about to the chairman of the panel. Thank you very much. Press briefing, first session of the Independent Judicial Accountability Panel
I got from March 4 to 6, 2026. And if you feel I do, distinguished ladies and gentlemen of the press, I welcome you to this briefing in the outcome of the fourth session of the Independent Judicial Accountability Panel IJAP convened under the auspices by CAA. IJAP began as the technical working group (TWG) of the citizens-led engagement judiciary in Nigeria. Please justice. And has now involved with the panel that supports citizens' actions toward judicial accountability. The scope is no longer limited to electoral matters, but extends to issues of transparency, accountability, in Nigeria's judicial system. Now, highlights from the fourth ICAP session. The session focused on one, review of some sections of the recently signed 2026 electoral act. And two, the judgment on the emergency rule on River State. And of course, we have another comment on the decision in Sunday. Starting from the 2026 electoral, we noticed a number of ambiguities in the act. And we are concerned for now with some of the sections. You recall that section 60 subsection 3, the one that deals with transmission, and it has a proviso. And one of the things we observed is that the words that at all times used in the proviso can be given different meanings. So it is not clear. At all times, for example, to mean after there is failure of electronic transmission. That's one possibility. It could also mean whether or not there was the failure of electronic transmission at all times, PC needs those to be relied upon. This puts a doubt on whether there could be sole reliance on formicity manually when there was no electronic transmission by reason of communication thing. Again, one of the things you have under the section 60 sub 3 is that it did not specifically talk about the verification and confirmation of the manual result initially with the electronically transmitted result. Even though there was an attempt to do that in section 62 subsection 4, it is for this reason that IJAP now puts up a draft that is utilizable for the purpose of an amendment. And below here you see in the draft, I quote, the election officials designated by the commission that electronically transmit all election results immediately after the prescribed result forms have been signed and stamped by the election officials and countersigned by the candidate or polling agents where available at the polling base and collation center to a public portal designated by the commission. The transmitted results shall be used to verify and confirm any other results before it is collated. You will see that one of our issues is that it shall be confirmed and verified. You find it in section 62.4. It should actually be section 63. And that's where we are putting the proposal in relation to section 63. The Electoral Act, the new one, the 63, talks about transmission to the IRA, but we are avoiding the use of particular names because under the old regulation that was formed, that was made under the 2022 Act, actually INEC regulation talked about a collation system and an IRA for transmission. Therefore, it wasn't limited at that time to what do you call it, IRA. For this reason, the new act has not done enough, and that is the purpose of this our new act. There are other ambiguities. For example, you find out that section 63, 65, 62(4)(a) and B, they use the word transmit differently. In some you find electronically transmit, in some transmit, and some transmitted directly. This we feel will be misleading in terms of judicial interpretation, and therefore we make further suggestions that, for example, in section 60 of 5, provides that the presiding officer shall transmit the results, including the total number of accredited voters, to the next level of collation. It did not say in that 60 of 5 which one, electronic, is it the manual, because we have some other sections talking about physical delivery of results. This we feel should be clearer to the public. The subsection equally does not say whether it can refer to is electronic or manual. And when 65 talks about the presiding officer transmitting to the next level, the only possible next level for the presiding officer at the polling unit to transmit is actually the word of the RA level. So these are some of the things that we notice are not very clear. Then we went to section 83 of section 5, which talks about an outside clause for the primaries of political parties, and it says that the courts will have no jurisdiction to entertain such. Well, that will be reiterating the position of the law, but we feel that it can just not end there, because when such cases, if they are in breach of the Constitution of the Federal Republic of Nigeria itself, then the court ought to entertain it. Are we together? The court ought to entertain it like that, so that the section should equally be looked into to say that because there could be challenges of internal party dispute, which will sometimes be tied to breaches of the Constitution. That should be taken into consideration in that area. We have said that, well, when we finish, we will be able to share thoughts on other areas. But this is how far we went in relation to the electoral activity ourselves. We now recommended that the electoral act be amended by the National Assembly to accommodate the above proposal, perhaps plus points. Then from there, for this briefing session, we went to the case, we looked at the case of Attorney General of Adamawa State and others, and Attorney General of the Federation and others. That was the Rivers State suspension of governor on assembly suit. And I will try to remind you of the facts of the case. The plaintiffs in that case challenged the constitutional validity of the declaration of the state of emergency and Rivers State, the suspension of the governor, deputy governor, and House of Assembly of Rivers State, and the appointment of the sole administrator, and the approval of the proclamation of the National Assembly. Secondly, the plaintiffs further sought for declaratory and inductive relief to prevent similar actions from being taken against their respective. We recall that these 8 governors of PDP, the Rivers State governor was not among them. In the suit, which sought the original jurisdiction of the Supreme Court. Now, the judgment has been given, we now commented as follows. Either for that, 1, that the delay in hearing and delivery of judgment in the case, coming only after the suspension had already been lifted, has the potential to undermine public confidence in the independence and impartiality of the judiciary. The decision rendered after the suspension was called off will have little practical effect on the rights of officials concerned, thereby raising questions about the timeliness and impact of judicial intervention. That's our first broad observation on that document. Second, as B, with respect to grant two of the plaintiff's claims in their suit, the Supreme Court observed that there was no clear dispute between the plaintiff and the Federation, which is said denied the court's jurisdiction to hear the case. This panel considered that a restrictive interpretation by the Supreme Court, we consider it a restrictive interpretation by the Supreme Court of the concept of course of action itself. In other words, if we are taking a more liberal approach, there will have been no point shutting up those 8 plaintiffs in their Adamawa suit. Thirdly, as C, in giving an opinion on the matter, the Supreme Court did not provide a clear answer on the scope of the exercise of emergency powers of the President in relation to the suspension of the governor, deputy governor, and the state of assembly, and finally, as D, the opinion of the Supreme Court seems to give the Senate leeway to rely on their standing order and avoid the insistence on the application of the constitutional requirement of a 2/3 majority in the approval of the powers of emergency. In other words, there should be no situation where 2/3 majority will be validly sustained by voice votes. This is our comment on that stage. And we recommend on that respect that in cases of national interest, such as this relating to constitutional interpretation, they should be asked immediately to build public trust in the judiciary as earlier recommended. At all times, important constitutional matters should be speedily addressed by the courts. 2 of B, the Supreme Court should be more accommodating of public interest litigation, which will entail a broader interpretation of course of action. C, 3, the Supreme Court should maintain the liberal and progressive approach to the interpretation of the provisions of the Constitution that was established in the case of Nafi or Agnew in state and such other cases as this panel recommended at the 3rd session. And D, on important constitutional issues, the National Assembly should use a roll call vote to establish the required 2/3 majority instead of a vote. Then number 3, that's call for clemency in the case of Sunday Jackson and the state. You recall that in the above case involving Sunday Jackson, who was arraigned and convicted on the charge of culpable homicide, punishable with death, and whose death sentence was affirmed by the Supreme Court in 2025. IJAP had in his earlier session considered the facts and circumstances of the case and resolved to intervene in the matter and to advocate for the grant of clemency to Sunday Jackson. The public panel therefore happily notes that the Adamawa State Governor on the 23rd day of December 25 finally granted him a pardon as advocated by civil society, including IJAP. Closing of the remarks, IJAP and Action Aid remain committed to fostering a more accountable judiciary and a transparent electoral system at the bedrock of Nigeria's democracy. The panel's broader scope will continue to enable interventions to not only focus on elections, but also uphold broader democratic principles, citizens' rights, and institutional reforms. Thank the media for their continued support in amplifying this effort for national and citizens' impact. Thank you very much.
Thank you very much, sir. What is going on away with a lot of those that are already? Okay, thank you. Thank you, Mr. Chairman. Gentlemen, Press, I go to you now. You have the opportunity to ask questions. whether on issues that have been discussed in this briefing paper or any other that you wish to raise questions on. Anybody?
Okay, I remain representing you from LCA. Okay, I just want to take us back to the issue of mode of constitution for the election. Now, for Canada, we are speaking with the camera. I'd like to get clarification on your position because the Electoral Act has provided for electronic transmission and manual at the same time. But this Electoral Act has recognized the IREN as a mode of transmission, but which was different from what we had in the 2022 Electoral Act. But this time around, it will also be verified with from PCHA, the areas where there are not no networks during the election that do not transmit to real time. I want to know if we are still having doubts on the provision of this section. What exactly are your concerns? That's what we want to know. Since the law has provided verification using the form PCHA and the IRA to verify the results coming from the polling.
There are two concerns. I said earlier that the verification and confirmation you think ought to have been part of section 60 of section 2, rather than the attempt that we made under section 62 section 4. That is one. And that is why we offer the draft that will write in which under section 60 of section 3 accommodates both the use to a portal nominated by IREN as well as the use of it for the purpose of verification and confirmation of it. Number one. The second is that if you look at the proviso, it now talks about at all times, PCA shall be able. What we are now saying is that the use of the word at all times shall at all times be subjected to various interpretations. We do know whether it is after the transition are totally filled or partially filled, or there could even be interpretation why there is no transmission at all. Those are the cases when that's the
Okay, my second question has to do with the state of emergency, the state of emergency in that case. We want to know why we are going for the use of voice rates, to determine the position of the state between state of the assembly. Are there issues with using voice rates? If there are no detected voices, maybe where people are protected,
Thank you. Thank you for your understanding. You see, what we are saying is that there should never be a situation when the institutions are specifically determined that particular percentage should be used as a root as a whole field where voice votes can be properly used. Because it will not be, practical or fair or for to say people are putting up their hands to determine interest majority or public interest. Emergency is so important to power. The constitutional state has to be proved of. We are now saying in all such cases that should be recorded beyond the standing or beyond the permissible situation in the standing order.
My name is Flora, from the Network. So you mentioned there are ambiguities and inconsistencies in the use of the word translation. Now, I want to understand in practical terms how will these ambiguities really affect the credibility of the next election. And I also want to confirm if you have officially, if IJAB has formally submitted the recommendation to the National Assembly.
Okay, let's take it one after the other. When you use electronic transmission in one section, transmission in another, and perhaps specifically manual transmit in yet another. Even though the definition section has said that transmit can be either electronic or manual and so on and so forth. In some cases, it could be said that what we did not say in one, we did not do in 10 days. Therefore, in specific situations, whether it is electronic or manual, we feel it should be specifically stated so that there will be no confusion or inconsistency. Before now, IDF has visited National Assembly several times. Some of the positions of IDF in relation to the constitutional amendment, the thinking of the and that's like advocacy for this.
Question, if these ambiguities are not corrected, does it create any room for these people after election?
It should not be impossible. It's quite possible. It's quite possible.
Okay, are there any other questions?
Only a strong member of the family. Terms of it for increase. Okay, so I think that's why the proposal would be for 63. We deal with possibilities or the chances of so much litigation. We've seen the number of litigations that go to our court system at election. Of course, more of it is pre-election cases. But after election cases, one of the tribunal, they are still a large number. These are the kind of things that promote those cases. So how do we define the very good? That's why the order is still there. And it's also coming from a living perspective. You need to say that very. We are not, I'm sure we are following the discussion, the conversation across the country. Should we accept this amendment or not? Or should we, this new act or not? Or should we amend it? And if we are going ahead to amend it, I just have looked at it and there are several reasons why it should be amended. Some of that is this discrepancy that I've identified. And what is the citizen's perspective? What is the citizen's feeling about this? Majority of what are they saying about it? I think that's the perspective we are taking on the middle of family. We credible and transparent election at the end of the day. We would, of course, this recommendation we will send it to the National Assembly, including these aspects that talks about the transmission 63. We would also be picking it up as civil society in terms of engaging with the National Assembly from roundtable conversation to including strict actions to get the National Assembly or the lawmakers to push this. We would make sure we would also pursue and look at the possibilities of not possibilities, pursue and encourage citizens to pick up this issue. We have the right up there somewhere in the banner there. We'll also promote and push it and make sure that citizens also pick this up, take it up with their legislators, with their senators, the House of members, and see how we can go about it. One question that might come is, when should this be done? Can this become between now and the next election? The answer is yes. We've seen it's not something that is too tedious or too difficult to do. If the executive and the legislators are in support of this, or they want this to happen, I think it can happen in 2 days, in 1 week. They can get it done. They can do a public hearing, do all the necessary press, second and third reading, and get it passed. And I think it's a good thing for the president or the executive to be in support of this process. There are other things that will follow. We expect that INEC would have its regulations and guidelines amended
based on this new act. So whether the act as it is right now, or even if they take up this proposition, we expect that INEC is going to have its regulations and guidelines amended, and civil society, including IJAL, we are also available to support INEC to interpret and give light to some of these issues within the act. Thank you.
Majority. I think that the only reasonable interpretation of that section of the Constitution is that you require a division of the House. Because you require about 73 senators to support before you can say you have defeated majority. Now, with a shouted voice vote, it is not possible to determine that 73 senators actually supported. And that is what the fundamental problem is. It's not that there's any, in the standing orders of Senate, you can use register, you can use electronic voting machine, you can use vote. Yes, but where the Constitution clearly states that 72 or 73 senators must support, then you cannot use a shouted voice vote to determine that. That's the point we're making.
And in other words, it's very difficult to count voices. There will be a division. These are very important constitutional matters, and there was stick to the rules of the provisions of the Constitution. Call for a division, so you are sure that you have to require either two-thirds or 4/5. It's like, I mean, the constitutional amendment process that is ongoing now. It requires that for every amendment bill, there should be a 4/5 majority. And you cannot determine that with just a voice vote. That's the point that I think is the same as with this declaration of state of the emergency. Any additions?
Imagine we wake up one day and we use one day to impeach the president of Nigeria. No, so let's push it. It's the same requirement. It's simple as that. So we wake up one day as a country and we say it and we have a state. Those support the and we say that's the judge. And they pick the president. Imagine the constitutional crisis will be in. So let's not make light of such issues. The Constitution showed that for specific reasons to safeguard. It requires that number. I believe that if you don't have up to 73 senators in sitting that you cannot. It's not two-thirds of those in attendance. Two-thirds of all members. So you cannot find a way of maneuvering yourself around it or get out of it because you don't have the quorum. It is Constitution, and we all have to adhere to the ground law of the country.
Thank you. And thank you so much. If there are no further questions, we would like to thank you for coming and expect that you will do the needful and the necessary and give this as much publicity as possible. Thank you very much, and we wish you the very best of the weekend.
Sorry, just to extra for the TV radio stations that want video live appearances and all that. We have the chair in town, so he's around because doesn't live in Abuja. He's around between now and Monday to attend to just arrange by our media team and we're able to sort that out. Even if you want any of the members of IJA, they're able to arrange that money or